Leonard, what happens after bankruptcy is filed?
Well, immediately after a bankruptcy is filed, the bankruptcy court, within maybe about 5 or 6 days, sends a notice to everybody you listed as a creditor in your schedules and statements that you filed with the court. So all your creditors will get a notice in the mail, assuming, of course, there's a good address. And that indicates to them that they have to stop calling, bugging, suing, garnishing, repossessing, or all these collection activities have to stop by law because there's an automatic injunction that kicks in as soon as you file called the automatic stay. About a week, maybe 2 weeks into it, you will get a letter from your trustee who's automatically appointed in your case. Whether 7 or 13, you get a trustee. And in this letter, you'll get what's called the trustee's questionnaire, where they'll ask you some basic questions, kind of a rehash of what has gone over with us. For example, they'll ask you some of the basic questions about your qualifications to file for bankruptcy. And it's kind of the yes or no kind of answer format. They'll ask you for some supporting documentation to be mailed back to them within maybe a 7 or 10-day period. The information will be some of the same things you've already previously produced, like your tax returns, your pay stubs and your bank statements, and copies of titles to vehicles. So these are some of the things that you are going to mail to the trustee. Now, about 5 weeks into the case, you will get a hearing. Now, it's called a first meeting of creditors, and everybody, whether 7 or 13 who files for bankruptcy, gets to participate in this. It's mandated by law. Now, your job is to show up with a driver's and social security card in hand, or an original W-2, and basically submit yourself to be asked a couple of questions. Now, the hearings are really easy. You just need to show up and breathe and answer the basic questions. The questions are straightforward, like your name, your address, your phone number, how long you've lived in Arizona, if you filed for bankruptcy before, if you filed for bankruptcy under some other name or under some other social, if you have any personal injury or lawsuit pending. They're asking you these things because they want to see if there's any assets that they might be able to get. The trustees get a commission for taking things from you. And 90% of the time, there's nothing for them to take if your lawyer did their job. So a lot of times there's nothing, but they ask anyway because it's sort of their job. And so usually the meeting's over in about 5 minutes, maybe even less. The meeting is also an invitation for creditors to show up and ask you questions. Because remember, there's this court order that says they can't call you and ask you about their stuff, about their bills and their accounts. And here's their opportunity to show up. Believe it or not, 99% of the time, nobody shows up. So the only people going to be there is going to be me, your lawyer, you, and the trustee. The hearings aren't private. They're done with 8 to 10 other people in 30-minute increments all day long. So it's going to be you and these 8 other people and the trustee and your lawyer and their lawyer sitting there waiting for their turn. Those meetings are recorded. And but again, it's 5 minutes. It's really the easiest hearing you'll ever have. The trustees are not judges. They're lawyers, and sometimes not even lawyers. They're Justice Department appointed collections agents. 90% of the time have nothing to do in your bankruptcy case. After that, within 60 days, your case will get discharged. So after the meeting of creditors, there's really nothing for you to do. The trustee might contact you or us with requesting additional documentations or clarifications. Again, about 80-90% of the time, there's even none of that if the paperwork's done right. So showing up at the hearing with the driver's and social security card, answering your questions, and then waiting for another 60 days or so is really all you have to do. Your discharge order comes in the mail, and it usually comes about 4 months, maybe 4.5 months after you started the Chapter 7. If it's a 13, then you're in a 3 to 5 year payment plan. You won't get your discharge for 3 to 5 years, but there's no other hearings in the 13 either. So that's what happened after you file your case.